Yes, Mr. Manning.
My Lords, my Lady, I appear for the Appellants this morning, while learned friend Lord Murray appears for the Respondent. My Lords, my Lady, these four appeals are about paragraph SW 1.6 of the Immigration Rules and the Secretary of State's residual discretion outside the Immigration Rules. The appellants apply to the Secretary of State for leave to remain as skilled workers and for leave to remain outside the immigration rules.
Can I just check? Is that second statement true of all of the appellants? I think it's certainly true of three, but Mr. Periyasamy, I'm less sure about. But come to that in due course.
I will, my Lord. The Secretary of State, as the Court knows, declined to consider their applications, rejecting them as invalid on the basis that the requirements in paragraph SW 1.5a of the immigration rules were not met. In each case, the Upper Tribunal refused permission to apply for judicial review, holding that the Secretary of State's decisions were unarguably lawful. And my Lords, my Lady, I shall seek to persuade you that the Upper Tribunal's decisions are wrong. Each judicial review claim has a real prospect of success. Each claim is arguable and merits a substantive judicial review hearing. Subject to any observations, what I propose to do is to address you first on law, taking you to the relevant rules, authorities, and policies, and I will then make submissions on the facts of each case. So the law first, behind tab 3 of the authorities, behind tab 1 of the authorities bundle, my Lords and my Lady will find section 3 of the Immigration Act 1971. When the Secretary of State grants leave to enter or remain to a person, she exercises her discretion under subsection 1b. My Lords and my Lady will see that subsection is not subject to meeting the requirements of the immigration rules. In other words, compliance with the immigration rules is not a prerequisite for the exercise of discretion under that provision. Immigration rules are made, as the Court knows, under subsection 2, which my Lords and my Lady will find on the next page. The authority, the key authority that concerns the nature and ambit of section 3.1 is the judgment of the Supreme Court in Munir, which is tab 8 of the authorities bundle. In that case, the Secretary of State argued that when she grants leave to remain to someone in the circumstances where the requirements of the rules are not met, she is not exercising her discretion under section 3.1 of the 1971 Act. In other words, she submitted that it's not pursuant to the statute that she grants leave. That was a submission that was rejected by the Supreme Court, and the paragraph in the judgment that is relevant for the purposes of my argument is paragraph 44. You have that paragraph at page 169 of the bundle. My Lords and my Lady will see that Lord Dyson said that the source of the power to grant leave is the 1971 Act. The Secretary of State is given a wide discretion. The language of the relevant provisions could not be wider. They provide clearly, without qualification, that where a person is not a British citizen, he may be given limited leave to enter he may be given leave to enter or limited or indefinite leave to remain, and they authorize the Secretary of State to grant leave even when leave would not be granted under the rules. Now, how that applies in the context of applications made under the points-based system was dealt with by this court in a case called Bihari. You have that authority, my lords and lady, behind tab 10 of the authorities bundle. There were two appellants before this court. Mr. Uller, the second appellant, applied for leave to remain as a student. He wasn't able to meet the requirements of the immigration rules. The Secretary of State refused the application on that basis. One of the two grounds of judicial review was that the Secretary of State erred as to her residual discretion and acted unlawfully in failing to consider granting him leave outside the rules. That argument is dealt with at page 188 of the bundle under the heading Uller and discretion. And if you look at paragraph 38, you'll see that that the court took the view that there was no doubt that there was a general discretion to grant leave outside the immigration rules, and the point then made is that there was no request by Mr. Uller in the application to exercise that discretion. You'll see that it was accepted in that case that there is no obligation on the Home Office to consider its discretion outside the rules in every single case. And in the next paragraph, the court identified two classes of cases where the Secretary of State is obliged to consider such grant. Paragraph 39, there is an obligation, I do emphasize on the word obligation, to consider such grant when expressly asked to do so, and if but briefly, deal with any material relied upon by the applicant. So where an applicant asks the Secretary of State to grant him or her leave to remain outside the rules, the Secretary of State is obliged to consider that grant. The second class is cases where there is no such request, but the facts are so striking so that it would be irrational not to consider grant of leave outside the rules. So these are two classes of cases where the Secretary of State is obliged to grant leave outside, to consider granting leave outside the rules.
Is that passage strictly speaking obiter?
Strictly speaking, yes, but in my submission, it is correct in law
And persuasive.
and persuasive.
Thank you.
Well, lady, given that I mean, you have properly noted that this is strictly speaking obiter, may I also take you to one other judgment on the point, and that is behind tab 11 of the authorities bundle, the judgment of this court in Anwar. So this concerned imposition of immigration conditions. The immigration rules, in short, stated that if a person is granted leave to remain as a student, he or she shall be granted leave subject to certain conditions. The Secretary of State argued before this court that that rule was enough so as to automatically impose a condition in every single case. In that context, there is a discussion as to Munir, Section 3(1) of the 1971 Act, and what was said by the Supreme Court in Munir. May I ask you respectfully to go to page 203 of the bundle? There were a number of other issues in the case, but may I ask you to look at paragraph 66, one of 6 reasons given by this court for rejecting the Secretary of State's argument. And one reason was based on the judgment of the Supreme Court in Munir on the paragraph that I've just taken you to. It is always open to the Secretary of State to take a decision which is favorable to a person, despite what the rule says. And if she chooses not to do so, that would have to be made clear in an individual case. In my submission, that is consistent with Bihari, where a person asks the Secretary of State to grant leave outside the immigration rules. The Secretary of State has to deal with that request and decide it one way or another. So these, my lords, are 3 authorities on Section 3 and the power to grant leave outside the rules. May I then, the Secretary of State, of course, acknowledges the existence of that power, and she has promulgated 2 policies. And may I just take you to the 2 policies in turn. The first is behind tab 6 of the bundle. This is a policy entitled Leave Outside the Immigration Rules. Now, if you look at page 128, the historical position, my lords, my lady, was that what is now called leave outside the rules was once called exceptional leave to remain. This is second paragraph under the heading background. That was then changed to what was called discretionary leave to remain. The Secretary of State has now sort of abandoned the use of those phrases, and when she now grants leave to remain outside the immigration rules, it is called LOTR, leave outside the rules. Now, may I ask you to look at the second last paragraph, please, on that page. LOTR on compelling, compassionate grounds may be granted where the decision maker decides that the specific circumstances of the case includes exceptional circumstances. And that, the policy makes it clear, is entirely distinct from human rights legislation. So it's not about private life or Article 3 or Article 4 Refugee Convention. This is simply where someone does not qualify under the rules or on human rights grounds, but there is something else that is exceptional so as to warrant grant of leave. If it's Article 8 or Article 3 or the Refugee Convention that warrants that leave, then that leave is granted now under the immigration rules. Last paragraph, not all LOTR is granted for the same reasons, and discretion is applied in different ways depending on the circumstances of the claim and the applicant's circumstances. In what circumstances will the Secretary of State grant leave outside the rules is dealt with on the next page, page 129. You'll see a heading, Reasons to Grant LOTR. And if you look at the last sentence on that page, page 129, the decision maker must, and I ask my lords and my lady to to highlight the word must, the decision maker must consider whether the application raises compelling compassionate factors, which mean that the Home Office should grant leave outside the rules. Must and should. Of course, it's not possible to define exceptional circumstances, but the policy says that such circumstances, such factors may include, see the next page, emergency or unexpected events. For the reasons that I will come to, these are cases relating to unexpected events or potentially unexpected events. And also a crisis, disaster or accident, this I say is potentially a crisis that could not have been anticipated. So where there are those factors, the Secretary of State may grant leave, but even where there are those factors, the Secretary of State may decline to grant leave. See the text that appears immediately after the bullet points. If it is reasonable to expect an applicant to leave, despite these factors, the Secretary of State may legitimately refuse to grant leave. But the obligation in my submission is to consider that grant.
And presumably, if the Secretary of State considers that it would be reasonable to expect the applicant to leave the UK, the Secretary of State should say so when refusing.
Precisely.
Yeah.
And if the Secretary of State says so, that decision is only amendable on conventional public law grounds. But this, for the reasons that I will come to, are not those cases. The Secretary of State is knocking out the applications at a prior stage, saying that I'm not even going to look at the applications. Process. How is it that a person may apply for leave to remain outside the rules? That is dealt with at page 132. You'll see a heading process, and then you'll see a heading applying in the UK for leave outside the rules. Now this is, in my submission, a passage that is of sort of central importance to the argument that I'm making. The applicants in the UK must apply on the application form for the route which most closely matches their circumstances and pay the application fee and charges. So you don't simply send in a letter. You must make the application that most closely matches your circumstances. Take example of a person, my lords, milady, who is a student. He is in the middle of his course and he wants to apply for further leave to remain. But for one reason or another, he is unable to meet the requirements of the rules. He has no funds in his account for whatever reason. The parents were not able to send funds, or he failed his exams for an illness or for some other compelling reason, a tragedy in the family. That person cannot qualify under the rules. That person will make an application for leave to remain as a student, pay the fee and charges, and within that application, that person is required to set out compelling, compassionate factors that they want the Secretary of State to consider. And that must be raised, the policy is, within the application on their chosen route for it to be considered. So in other words, if a person makes an application, a sort of freestanding application on a form that does not closely match their circumstances, that would be inconsistent with the Secretary of State's policy. The Secretary of State would require that person to make the application that she says that person must make and pay the relevant fee.
Can you help me with this? If you're a student, but your application as a student is utterly hopeless because you don't meet any of the requirements.
Yes.
It doesn't match your circumstances at all. Do you still use that form according to this guidance, or do you go for the second option, which is to ask for consideration solely outside the immigration rules?
So if you are a person who wants to stay in the country to study, despite the fact that you don't meet the requirements of the rules, in my submission, you would make an application for leave as a student and set out the circumstances why you should be granted leave, despite the fact that you do not meet any of those requirements. But if you wish to study, if you wish to stay in the country not to study, but for some other reason, then you would go for the second option and use the FLR HRO form.
Thank you.
I mean, take the example of a student who is pregnant, who has completed her course of study, but has been advised not to travel. So she would seek leave not as a student, but simply on the basis that, well, I should not be required to return for next 3 months or 6 months or 1 year. So that person would go for the second option. But I again, with respect, emphasize the word must. So the applicants are told very clearly that you must apply when you are seeking leave outside the rules on the application form for the route which most closely matches your circumstances. Now, what would the Secretary of State do when she receives such a form and an application? That is dealt with on the next page, page 133. You'll see heading granting leave outside the rules. So the Secretary of State in the decision would say that the requirements of the rules are not met, but the Secretary of State would set out why she is granting leave outside the immigration rules. And what is it that the Secretary of State should do when she refuses the application? The point that Lady Justice Elisabeth Laing made is dealt with on the next page, page 134. What the Secretary of State should do if she refuses leave outside the rules. The Secretary of State would set out the reasons why the requirements of the rules are not met. And then, along with the refusal outside the rules, the reasons for that must also be included in the decision. The reasons must explain what factors the applicant raised and what evidence has been taken into account before going on to explain why they do not warrant grant of leave. You must explain why discretion has not been exercised to grant leave outside the rules in each application on a case-to-case basis. And then you'll see a hyperlink, see refusal wording. If one clicks on that link, that would take the person to the text that you have at page 136. So this is the Secretary of State's policy, 136, the refusal wording. So where a person does not raise exceptional circumstances, the Secretary of State can simply say that, well, I've considered whether there are exceptional circumstances. You haven't raised any exceptional circumstances, so leave outside the rules is not appropriate. But when exceptional circumstances are raised implicitly or explicitly, this is the point in my submission in Bihari, where a person expressly raises exceptional circumstances, or the facts of the case are so striking that they warrant consideration of that grant. And see the wording. The first part, the Secretary of State acknowledges the request. Secondly, the policy is that in support of your claim, you state, the policy is that the Secretary of State will set out a summary of the circumstances that are claimed. And then you have submitted, insert details of evidence submitted. So again, the point that was made in Bihari, you must engage with the evidence. So identify the basis, you engage with the evidence. You then say that you don't qualify for leave outside the immigration rules, and you then give reasons why circumstances are not exceptional or why it isn't appropriate to grant leave outside the rules. So when the Secretary of State knocks out an application, rejects his application where a person has sought leave outside the rules on the basis that a requirement in the immigration rules is not met, she defeats the purpose of this policy. She frustrates, in my respectful submission, the scheme of Section 3.1 of the 1971 Act. This is the context in which, in my respectful submission, my lords and my lady will consider each case. The second policy document is behind tab 5. This is a policy called validation, variation, voiding, and withdrawal of the applications. And may I just take you to the relevant part of the policy, which you have at page 107. You'll see heading requirement previous leave. Now there are the sort of validity requirements that the court will consider in this case are the sort of validity requirements that are part of a number of categories in the rules. Routes, the policy says, have their own validity requirements, and then an example is given for appendix skilled worker and SW 1.5, the paragraph that is relevant. I'll take you to that in a minute. But the point is that in order to apply for leave as a skilled worker, one must not be in the UK as a visitor or a short-term student. But the Secretary of State accepts that there can be exceptional circumstances. Take example of a person from Ukraine. The example that is given in the policy, who comes to the UK, say, shortly before the invasion on a short-term visa. Then the invasion, and that person cannot realistically be expected to return to Ukraine to apply for entry clearance to come back as a skilled worker. If the person gets a job in the UK, then the Secretary of State acknowledges that there is a discretion.
But I think it was implicit in your opening remarks to us that on your case, there are in principle, I mean, the two questions may shade into each other in particular for actual circumstances, but in principle, you say there are two different questions. Question one, if someone is applying under the skilled worker rules and their application is invalid, does the Secretary of State nevertheless have the power and therefore the discretion to waive that invalidity? But that's all about an application under the rules,
yes,
which turns out to be invalid and waiving the invalidity.
Yes.
That's question one. But then there's question two, which, as I understand it, you said is a distinct question, which is, in any event, there's the question of LOTR. If that's either expressly requested or it's so blindingly obvious that it would be irrational not to consider it. Do I have you correctly?
Yes.
Thank you.
And my lord is absolutely right that it's ultimately the case that the 2 points actually merge because the Secretary of State has to first accept the application to consider it before she embarks on considering the application. Where the requirements of the rules are not met, and where the relevant conditions are met, where there is an express request for exercise of discretion and effects are so striking, the Secretary of State has a discretion to accept the application despite the fact that the validity requirements are not met. and to either refuse or grant leave outside the rules. If she grants leave, she can say, in accordance with the policy that I showed you a minute ago, that you don't qualify under the rules, but I'm granting you leave outside the rules for these reasons. If she's refusing leave, she would say that you don't qualify under the rules for these reasons. I've looked at your evidence, and for these reasons, I do not consider that your circumstances are exceptional enough to warrant the grant of permission to stay. If the Secretary of State takes the view that it's not appropriate to exercise discretion, then she would write to the applicant saying that she cannot meet the requirements of the rules, giving them 14 days to make another application. If they do not make another application, then the Secretary of State would refuse the application, would reject the application. Now, the submissions that I've made thus far and the policy documents that I've shown you were not an issue in the case of Islam. Islam is a case where there was no request by the applicant for grant of leave outside the immigration rules. And the facts were not so striking so as to warrant such exercise. For that reason, there was no consideration, none whatsoever, to the position outside the immigration rules. So Islam is the authority next that I'll take you to deal with the submissions that my learned friend makes. So tab 12, page 209, and you'll see facts set out succinctly at paragraph 1. Mr. Islam made an application as a skilled worker, and that application was accompanied by a certificate of sponsorship. And that was it, really. So no request for grant of leave outside the rules.
Sorry to interrupt. This is a rather trivial point, but I just want to check my understanding is correct. My belief is that this case has been reported. We don't seem to have the report. I'm not jibbing at the absence of provision of the report. I just want to check that my memory is correct, that it has actually been reported.
I'm fairly certain that it hasn't been reported, but I will double check. I did check.
All right. Well, if it hasn't, it hasn't.
When the bundle was prepared,
it seems a little surprising because one would have thought it would have been.
Yes, anyway. I may have missed it, but I'll check the position over the lunch.
Thank you.
So paragraph 1, so the application was simply accompanied by the certificate of sponsorship. There wasn't any request for exercise of discretion. The Secretary of State rejected the application as invalid. There was no minded to reject letter in that case. And that case was, you'll see paragraph 2, it was accepted that the application was invalid. Now, that case, in my submission, was simply about proper construction of paragraph SW 1.6 of the immigration rules. Now, the relevant rules are set out at paragraph 6, and you'll see SW 1.5a at page 213. So in order to qualify as a skilled worker, an applicant must meet one of the 3 conditions, A, B, and C. In short, the condition is that if you come to the country as a student, then you must complete your course before you apply for leave, unless you're studying for a PhD. Or there is another condition. There is no dispute in this case that those conditions are not met. But see 1.6, an application which does not meet all validity requirements may be rejected as invalid and not considered. the issue before the court was about construction of word may in that paragraph. Now, if you go to page 215, you will see that because the issue in that case was about construction of the rules, the court was taken to some well-known authorities on proper construction of the immigration rules, and submissions were made as to the exercise of discretion under the immigration rules and how various courts have construed the word may. The conclusion is at paragraph 28. This is where the court, Lord Justice Peter Jackson, addresses a proper meaning of the word may. Middle of paragraph, he says, may is a complex word. It has 4 different meanings: is permitted to, has power to, is entitled to, or is absolutely entitled to. And the court took the view that on proper construction, may in that paragraph means is absolutely entitled to. That, of course, is binding, and I accept
Well,
that.
not only that, my understanding, and correct me if I'm wrong, is that the Supreme Court refused permission to appeal.
Yeah, indeed. So that stands. Paragraph 35, ultimate conclusion. I therefore conclude that paragraph SW 1.6 and the similar provisions elsewhere entitles the decision maker to reject an application. Now that, in my submission, is an application that is made solely under the immigration rules, where there is no request for leave outside the rules. That has been properly determined to be invalid without further consideration, and judicial review will not lie in respect of such rejection. This, in my submission, does not apply to an application that is made outside the immigration rules, pursuant to the authorities that I've taken you to and the policy document. Just one final paragraph, paragraph 44. Lady Justice Andrew gave a short supplementary judgment. She accepts, of course, that there is a discretion, there is a power to accept an application despite the fact that the requirements of the rules are not met. And then last paragraph, the existence of the power to waive what would otherwise be a mandatory requirement does not mandate the decision maker to consider whether to do so in every case. I accept, but she must do so in 2 classes of cases identified in Bihari, namely where there is an express application for leave outside the rules, or where the facts are so striking so as to warrant that grant.
Well, that, of course, I understand. As you made clear, Islam was not a case about LOTR. So LOTR separate considerations arise. But can I be clear as to what your submission is as regards waiving invalidity under SW 1.6 itself, which, as we discussed earlier, is logically or conceptually a distinct question, albeit closely overlapping on the facts of some cases. What do you say about waiver of invalidity? Because what we learn from Islam is that the Secretary of State has the power to waive invalidity, but it's not mandatory for her to consider doing so in every case, or to explain, if she's not considering that, why she's not considering that. But do you submit that there is nevertheless a duty on the Secretary of State to give reasons if she is, on the face of it, purporting to consider whether to waive or not.
Yes. So the Secretary of State, in my submission, has two options, where an application is made which does not meet the validity requirement, but where there is an express request for leave outside the rules. There are two options. Option A is to exercise discretion under SW 1.6A, sorry, SW 1.6, and to say that I waive the validity requirement for the purposes of considering your application outside the immigration rules. And she would be perfectly entitled to do so for the reasons given at paragraph 44. So she's waiving validity requirements by exercising a power under SW 1.6. The second option would be to say that I'm not bound by SW 1.6, and I'm going to depart from the immigration rules and to accept your application outside the immigration rules, so as to consider whether or not to grant you leave outside the rules. The Secretary of State is obliged, in my respectful submission, to give reasons.
In either case?
In either case, where a case falls within the two Bihari categories, where there is an express application for leave outside the rules, or where the facts are so striking that they warrant grant of leave. Not in a case like Islam, where there is no request and no material facts.
Can I just ask you about two paragraphs of Islam in the light of that submission? In paragraph 28, which you took us to, Lord Justice Peter Jackson interpreted may as meaning absolutely entitled to.
Yes.
No qualification.
No qualification. Yeah.
The question that arises from that, but please don't answer it until I've come to the second point, is your submission consistent with an absolute entitlement? Because it seems to be a qualified right. And the second point is that in paragraph 34, Lord Justice Peter Jackson expressed surprise at the proposition that the maker of an application under the rules that have been properly determined to be invalid should have any further enforceable rights against the decision maker within the rules.
Yes.
And that's really the same point. He seems to be saying that so far as the rules are concerned, leaving aside any LOTR, the Secretary of State has an absolute right to grant or not to grant.
Yes. Yeah.
To waive or not to waive, and it can't be questioned, whatever the circumstances. And Lady Justice Andrews agreed with all of that, as did Lord Justice Phillips.
Yeah. So the submission that I make with respect is twofold. The first being that where the Code discusses an application in those paragraphs, that is an application that is made solely under the immigration rules, and there is no request for leave outside the rules. The second point is that, secondly, I have no difficulty in accepting this analysis. The point that, my Lord, you made, that does not defeat my case. So,
no, I don't think you need.
Yeah,
first point. If you've got your point about outside the rules, I don't think you need the waiver
precisely.
point.
I don't have an issue.
But as I understand it, your point on waiver is yes, Islam establishes an absolute entitlement of the Secretary of State to simply say this application is invalid. That's the end of the matter.
Yes.
However, it also makes clear that the Secretary of State has a power, no duty, a power to waive such invalidity.
Yes.
And your argument, as I understand it, is that the Secretary of State is not obliged to even consider waiving. It's an absolute entitlement, simply say this is invalid, that's the end of it. However, your argument is that if she does consider waiving and decides not to waive, at that point she has a duty to give some reasons.
Yes.
Yeah.
That is indeed the case. Earlier in my submission, I was simply setting out two options that are, in my submission, available to the Secretary of State in law. But I have no difficulty in proceeding on the basis that the application absolutely fails under the immigration rules. My Lord is absolutely right, that is my case. But there is one further point that I make, and that is the point that I have made. That if the Secretary of State sort of knocks out the application on the basis that the requirements of the rules are not met, well, she defeats the purpose of her policy. I mean, how is it, I invite my lords and ladies to consider, how is it an applicant can put her case before the Secretary of State for her to consider whether or not to grant leave outside the rules? If her answer would be that I'm not even looking at your application because you don't meet the validity requirements under the immigration rules, that would defeat the entire purpose of the policy that I've shown you. It would undo, in my respectful submission, learning from Munir, Bihari, and Anwar. So the Secretary of State, of course, must give reasons, and she must not exercise her discretion in a way that is vitiated by public law errors, which defeats her policy.
Right. So having established the basic architecture, the next question that arises is the extent of the duty to give reasons,
Yes.
if there is one.
Indeed.
So let's assume, for the sake of this discussion, that there is indeed a duty to give reasons. What's the extent of that duty in this context?
So that is, in my submission, set out in the case called Porter, a well-known authority, which you have behind tab 7. So this is the case where Lord Brown reconciles all earlier authorities as to the extent of the duty to give reasons for a decision. And may I ask you respectfully to go to page 148. So after discussing all relevant authorities, under the heading the law summarized, Lord Brown summarizes the law, and it's paragraph 36 that in my submission is the answer to my Lord's question. The reasons must enable the reader to understand what conclusions are reached on principal important controversial issues, disclosing how any issues of law and facts were resolved. Reasons can be given briefly, and then may I ask my lords and my lady to look at the text between D and E. The reasoning must not give rise to substantial doubt as to whether the decision maker had erred in law. So when I'm pursuing a reasons challenge, I need not to persuade the court that the decision maker has certainly erred in law. It's entirely different, of course, from rationality. If I'm able to persuade the court that there is arguably substantial doubt as to whether the decision maker erred, in my submission, the appeals should succeed depending on what the court says about the facts of each case. And you'll read the decisions in a straightforward manner. There is no reason to address each and every point. All that is well settled. And so this is law. The Secretary of State's policy the policy document that I told you, sets out what she considers should be done. She says in her policy that when someone requests leave outside the rules and she decides to refuse it, she will firstly give reasons why the requirements of the rules are not met. She will then acknowledge that there is a discretion. She will then, as the template shows, summarize what the case is. She will then summarize the evidence. She will then deal with the evidence and explain why the evidence does not demonstrate that there are acceptable circumstances, or she must explain that despite those circumstances, exercise of discretion is not appropriate.
If the Secretary of State complies with her own policy in that regard, as far as reasons are concerned, does a South Bucks, which is expressly about reasons in a planning context, really take us any further?
If the Secretary of State complies with this policy?
Or if she doesn't apply. I mean, in other words, do you need South Bucks to help you? If you say, well, here's the Secretary of State's policy, the way that this decision was made doesn't comply with their own policy, that's probably enough for you, isn't it?
It is, but this court and various other courts have said that South Bucks applies to immigration context too, this is what the position is on law. The reason why I felt that I should show this paragraph is to make the point that in order to succeed in a claim that concerns inadequacy of reasons, all an applicant has to demonstrate is that there is a substantial doubt that the decision maker has erred, not that the decision maker has certainly erred in law.
It's quite interesting because the actual issue in Porter was whether the inspector had given good enough reasons for explaining why the personal circumstances of this 60-year-old woman outweighed the environmental harm involved. And,
yes.
Lord Brown gave short shrift to the decision of this court that the inspector needed to say more about it than he did.
Yes. But you, of course, I'll now turn to the facts of these cases. But of course, the court has the sort of fundamental point that we are not even at that stage. The Secretary of State is obliged to give reasons why she is not granting someone leave outside the rules. We haven't reached that stage in these cases. Here, the Secretary of State is saying that I'm not even going to look at your applications.
Just before we get off the law and on to the facts, I observed that there's a case called Cower in the authorities bundle. Is in your submission, is that of any relevance?
No, none whatsoever.
Fine.
In my yeah, I say that, of course, with the greatest of respect and diffidence. Milady, of course, knows that that case wasn't about SW 1.6 or discretion outside the immigration rules. It's included here on Melanchthon's request. I think the purpose of putting this authority is to make an argument that the court should decline to grant any relief in the exercise of discretion. But I do not understand how one can make that argument. So unless there are any observations, I'll wait and see what Melanchthon says.
I'm sure that's wise.
That was, again, Milady knows about paragraph 39.
I've just reminded myself.
But this was all about...
Oh, yes. He's settled it too.
So paragraph 39E of the immigration rules, a provision in the rules which says that you cannot qualify for leave to remain if you are an overstayer for more than 14 days or if you are subject to a bail condition.
It's raised in relation to one of the cases because one of your clients was on immigration bail. I think that's the way it comes in.
Yes, but it isn't my case that he qualifies under the rules anyway. So that is beyond point.
Okay, so
this
the
is
facts.
so may I then address you on the facts in each case. So first, Kalidasan, the first appellant. So in the code bundle, may I ask you respectfully to go to page 132. So page 132 is the application form that Mr. Kalidasan used. And Lords Milady will see that page 132, the type of visa application is skilled worker. So this is the form that is used for skilled worker application. And if you go to page 138, you'll see that Mr. Kalidasan has a job offer. That is, the job offer falls within skilled occupation. So the Secretary of State has a list of occupations that are short in supply in domestic market, and you can only make this sort of application if you get a job offer from a sponsor, a business who is licensed by the Secretary of State to offer such jobs. And you'll see that Anika Limited issued a certificate of sponsorship, and the job title is Retail Manager, and the salary is £26,500. Paragraph 139, you will see a heading UK immigration status, and Mr. Kalidasan says, well, please look at the cover letter. Just for the purpose of your note, if you wish to see the actual certificate of sponsorship, it is at page 142, 143. So the scheme is that an employer first approaches the Secretary of State and asks the Secretary of State to assign. Firstly, an employer gets the license from the Secretary of State to sponsor skilled migrants. Once license is granted, the employer then asks the Secretary of State to assign a certificate of sponsorship so as to enable the employer to sponsor a migrant. He would need to satisfy the Secretary of State that the job is short in supply, it's a genuine vacancy, and meet a number of other requirements. Then this certificate of sponsorship is issued, essentially a job offer with job title and all other conditions. The applicant then makes an application based on that. So the cover letter that is mentioned in the application is at page 122. So this is a letter that is written by my instructing solicitors, and this is you should see that this is the irony about this case, that this person actually first made FLR HRO application using the second option, because when he made that application, he did not have job offer. So he couldn't sort of qualify on any view for leave as a skilled worker. But then he got the job, and he did precisely what the Secretary of State's policy required him to do, to put in this application that most closely matches his circumstances. He then, under the heading background, the letter refers to a witness statement and summarizes what the statement is, what the statement says. And I'll take you to that statement. go to page 128, you'll see a heading, discretion outside of the rules. The applicant expressly invites the Secretary of State to exercise discretion outside the rules. It refers to the relevant authorities, including Munir, the authority that I've shown you. And then paragraph 31 of the letter, page 130, he says that he was broken by theft within the agency. He trusted them. I'll take you to the statement in a minute. But then paragraph 34, he asks that he is granted leave outside the rules.
Right, he puts it both ways. So 33 says
Yeah.
SW 17.1. I'm not quite sure. That's just a formal rule, I think.
No,
and then alternatively, LOTR.
So so 17.1. These are the rules that set out the substantive requirements for being a skilled worker. So if he sort of crosses the validity threshold,
Right. Yes. Okay.
he meets all of the requirements.
Yeah.
He has a job offer. He has funds.
Yeah.
The vacancy is genuine. So he meets the substantive requirements, but he does not meet the technical validity requirement.
Yeah.
But he says, well, grant leave outside the rule in the alternative, and that's how the case is put. The witness statement is in the supplementary bundle at
It's
page.
slightly puzzling. Sorry, I've just noticed the penultimate paragraph of that letter on page 131. A reference to somebody completely different from the applicant.
Yes.
It's not an uncommon feature of these cases that there are many applications covered by the same solicitors, and sometimes template letters are not completely reformatted.
Absolutely. But in defense to my solicitor sitting behind me, I'll say this. If you look at, of course, the earlier part of the letter, I mean, this isn't, I mean, it's not sort of simply copied. There is discussion about the particular facts of the case, etc. Supplementary bundle, you have the witness statement at page 55. So he, in short, says that when he came to study, you'll see that he says that he's a good student, came to the UK to study. He used an agent, was required to pay a fee to the university. He paid to the agent, believing that he had done what he is required to do. The agent let him down, and there was a formal complaint against the agents. The agent said that his money was stolen by an employee. His father was unable to afford more fee. He borrowed money from the relatives to pay the initial fee. He then, paragraph 20, felt helpless, started drinking, he says, and his case essentially is that, well, for these unexpected reasons, he wasn't able to complete his course, which is one of the requirements for validity. He says that it wasn't my intention to avoid attending the university. I just couldn't pay the fee. He says that I've then found a job. It's on skilled occupations list. I have a sponsor. Paragraph 30. I had to discontinue because I was cheated by the agent. I've lost the money, disrupted my life, and Then paragraph 33, he says that, well, I humbly request the Home Office to exercise residual discretion and grant me a skilled visa.
At the end of paragraph 30, he also asks for the Home Office to use discretion.
Yes. Yeah. So this is that, and then asks the Secretary of State to do that. Now this witness statement is then supported by other evidence. If you go to page 46, you'll see that a letter from a lawyer in India. So his father, as he explained in the witness statement, sought legal advice, went to the police against the agent. The lawyer advised him that, well, the money is gone and there's nothing that you can do. If you go to court, you'll be spending more time, more costs. And
which page?
Page 46.
46.
Yes, page 46. The father agreed with the advice and settled the matter once the agent agreed to pay the fee back without filing a police complaint. His father also made a witness, and you have the ID card of, the registration of the lawyer on the next page, page 47 and 48. So he's the lawyer. The father also made a statement, page 49. He explains how they arranged funds to fund the study of their child, pay to the agent, explains how he borrowed the money to fund the education of his child. It's let down by the agent. He explains. Paragraph 12, he says he went to a lawyer, he went to a police station, demanded the money, requested additional time, but by the time the deadline imposed by the university lapsed, and Mr. Kalidasan wasn't able to study. Paragraph 19, the child, Mr. Kalidasan, found a sponsor, and he says at 23 that I also tried to obtain some evidence from a police officer, but they wouldn't issue me a letter. So his statement is, his claim is supported by his statement, by the statement of his father, corroborated by the evidence given by the lawyer. His case is that, well, these are unexpected events, a crisis that I wasn't expecting. I couldn't complete my study. Please exercise discretion, grant me leave. I meet all substantive requirements. I have a job, and grant me leave. The Secretary of State issues a minded to reject letter. You have that letter at page 43 of the same bundle, supplementary bundle. And the Secretary of State says, this is issued pursuant to the policy. The Secretary of State says that, well, I'm considering rejecting your application because you do not meet the validity requirements. And the requirement is that, well, you got to complete your studies first. And then see paragraph 44. Secretary of State says, well, I'm giving you an opportunity to submit an application under a more suitable immigration route, depending on your circumstances. Of course, this is indeed the most suitable route for him. He's required to respond within 14 days. He responded, and his response is at page 35 of this bundle. A letter that is written by my instructing solicitors. he says essentially that, well, please see my cover letter and what I have already submitted. You have my witness statement, and he explains again his tragic circumstances. Paragraph 12 of the response, he asks the Secretary of State to look at the letter from the lawyer, bar counsel, the registration of the lawyer, witness statement of the father's identity card. And then paragraph 39.
Well, it's worth
Page 39.
looking up at page 37.
Yes.
We get submissions in response.
Yes.
And helpfully there are distinct points identified. In D, Home Office failed to consider LOTR.
Yeah. Yes, indeed.
And then page 39, which you were going to, is all about LOTR.
Outside the rules.
Can I just ask about this? In the process of going through this, my eye was caught by the email at page 53, I think it is. This is in between the bits that you've been showing us. There was a request by the Secretary of State for documentary evidence to substantiate the claims about being cheated by the agent and correspondence with the university. That's all I've seen. It just looks as though that got lost in the process, as far as I can see, because that's not a basis on which the decision was ultimately made. Am I right about that? No, it's just, I can see why that was sent, but it doesn't seem to be followed through.
That is yes. That is right. Yes. I'll double check if.
Yes. Well, you don't need to answer now because you've taken us to the decision letter.
I'm grateful. Yeah. So, ground officer, page 39. The Secretary of State is then referred to her own policy, the policy that I've shown you, and then paragraph 27, in bold, highlighted, underlined, so that the reader gets the point. Guidance mandates the Home Office must consider exercising discretion. Again, taking into account these submissions, additional evidence. And then 28 is the conclusion. Exercise discretion under SW 1.6 or outside the rules. The rejection decision that is being challenged is at page 119.
I assume that's in the core bundle.
My apologies. Yes, core bundle 119. The first thing that I respectfully invite my Lords and Lady to note is what appears in the second paragraph under the names, etc. Your application has been rejected as invalid and will not be considered. So what follows is not consideration of whether leave should be granted or not, either under the immigration rules or outside the immigration rules. The Secretary of State is saying that I will not consider your application. The reason given by the Secretary of State is that the requirements of the rules are not met. There is a reference, we note that your representations were made on 18th of July 2024. We have taken into considerations, it has been decided discretion or leave outside the rules is not appropriate in this instance. Well, three short points. The first is one that I've already made. This isn't a consideration of whether leave should or shouldn't be granted outside the rules. These are reasons for not considering the application. Second, this obviously does not comply with the policy that I've shown you. So when the Secretary of State refuses to grant leave outside the rules, the policy sets out what she would do. She hasn't done that because she isn't considering that question. The third point, even if one ignores the first 2 points completely, is that there is no reference or engagement whatsoever with the evidence. This isn't simply a case of a letter. There was evidence in the form of the applicant's witness statement, his father's witness statement, evidence from his lawyer. There is no mention of the evidence, no engagement with it, no reasons why this isn't an exceptional case. Again, the Secretary of State's policy is that when she declines to grant leave outside the rules, she would say that your circumstances are not exceptional for X, Y, and Z reasons, or it's reasonable to expect you to leave. None of that appears in this decision. This is, in my submission, a fundamentally defective decision. The Secretary of State then quotes the relevant rules and then says that I'm rejecting your application. So how is it, again, the point that I made when I was making my submissions on principle, how is it that Mr. Kalidasan can put his case before the Secretary of State? He's declining to look at it on the basis that the requirements of the rules are not met, thereby defeating the purpose of our own policy.
Well, the passage that you showed us from South Bucks contains the usual thing in planning context, that you give a benevolent reading to the decision letter. If one applies that approach to this letter or email, the reference to the further representations in whatever it is, the 1, 2, 3, 4, 5th paragraph, says in terms, it's been decided that discretional leave outside the immigration rules is not appropriate in this instance. Is that not a decision not to grant LOTR?
My submission is that it's not a decision not to grant LOTR. The Secretary of State earlier in the decision says that I'm not even going to consider your application. If the Secretary of State had accepted this application for consideration and decided not to grant leave outside the rules, she would have followed her policy and explained why there are no exceptional circumstances, etc.
Well, I can see the force of your argument that there's no reasoning, there's no application of the policy, but you say that fairly read as a whole, this letter doesn't even amount to a decision not to grant LOTR.
Exactly. And the Secretary of State isn't suggesting, unless she suggests today that this is a refusal of grant of leave outside the immigration rules. But, my Lord, as I respectfully submitted, even if I'm wrong about everything that I've said, I do submit that this does not even meet the South Bucks standard. You got to engage with the evidence. This does not enable, in my submission, the reader, Mr. Kalidasan, to understand whether the Secretary of State accepts his accounts or rejects it. Whether she's saying that, well, this is all a fabrication, or whether she accepts it. Or if she rejects the account, why that is so. And if she accepts the account, the letter does not tell the reader why that account isn't exceptional, why it isn't an unexpected event, or a crisis that wasn't anticipated.
And finally, even if all those points are dealt with, there's the question of would it be reasonable for him to leave and make the application from outside the UK, and that's not dealt with either.
Yes, but yeah, precisely. You haven't. Yeah, lady's absolutely right. So this is a rejection that, in my submission, is plainly defective and unlawful. The Upper Tribunal's decision refusing permission to apply for judicial review is at page 66 of this bundle. And the real point is at paragraph 6, page 67, which is that the Secretary of State was not arguably required to do more than to consider the circumstances put forward. And she has referred, and she has in mind the representations, and then decide whether to exercise discretion in paragraph 1.6. Of course, my point is about discretion outside the immigration rules. I do say this with respect to the judge. I mean, the real question for this court is whether the Secretary of State's decision is defective. I mean, if the court concludes that that decision is defective or is arguably defective, it matters not with respect to what the Upper Tribunal has said. Really a question for the court. This isn't.
And this decision, I've just recalled the chronology. This decision was before the decision in Islam.
Yes, indeed.
Indeed, before the hearing in Islam, I think.
Yeah. And as I said, we are not in a sort of territory where the tribunal has made findings of fact and where this court would give due deference. This is a refusal of permission to apply for judicial review. It is really for the court to decide whether to grant permission or whether the claim is arguable. In my submission, plainly arguable, and in my submission, it's a good claim. The decision is effective.
May I ask you a question, please, about paragraph 24 of the grounds for judicial review? So paragraph 24.
Which page?
Oh, I'm so sorry. Page 117. So in paragraph 24, there's a reference to a grant of PTA by Lord Justice Newey. Is that the grant of PTA in Islam?
Islam, yes.
I just wanted to check. So that doesn't appear to have been dealt with by the Upper Tribunal at all, or has it been in some way that I've missed?
No. No. Now, I'll address you on other cases now, but may I just make this point, and I've dealt with that in my skeleton argument. I mean, if this was an appeal from the High Court, a decision made by the High Court refusing permission to apply for judicial review, instead of, as the court knows, instead of granting permission to appeal, the court can simply grant permission to apply for judicial review and deal with the underlying judicial review application. That, because of a lacuna in the legislation, is not an option that is available to the court when considering an appeal from refusal of permission to appeal from the Upper Tribunal. NB is the authority.
Well, yes, indeed, and that was why I followed the customary course in these circumstances when giving PTA of inviting the respondent to consider whether to consent to permission to apply for judicial review will be granted, but the respondent decided not to.
No, and I'm pretty sure, my lords, my lady, you have extensive experience of dealing with these sort of cases, but I'm sure you will struggle in recalling a few examples where cases of this sort have come before this court. In almost all these cases where a judge of this court says that, well, there is something in the case, the parties agree that the decision to refuse permission to apply for judicial review is quashed, permission to apply for judicial review is granted, and there is then a substantive hearing before the Upper Tribunal. But that has not happened, of course, because the Secretary of State has decided to refuse decided to defend these appeals. If the court, I mean, of course, as I submitted, all I need to persuade you today is that there is a real prospect of success. But this, of course, is a hearing that will take for a full day. If, having heard submissions from both sides, the court comes to a conclusion that the rejection is indeed unlawful, and there would be no prejudice to the Secretary of State, then as a matter of law, it would be open to the court to allow the appeal, set aside the decision, grant permission to apply for judicial review, and quash the underlying decision.
So, can I be clear about that? Although at PTA stage, the single LJ has no power, in a case of this nature, to order that permission to apply for judicial review be granted. You say the full court,
Absolutely.
On the substantive, on the appeal, does have that power.
Absolutely. But you will only get to that if you allow this appeal. You set aside the Upper Tribunal's decision refusing permission to apply for judicial review. You then exercise the power that you have to make any decision that the Upper Tribunal may make, grant permission to apply for judicial review, and you then again exercise the power that you have to make any decision that the Upper Tribunal may make and quash the rejection decision. But whether you should exercise that power, of course, would depend on what Muller says, because...
But to be clear, you're inviting us to do that. I mean, it's sufficient for your client's purposes,
Yes.
for the appeal to be allowed and for the matter to proceed to a substantive hearing in the Upper Tribunal. However, as I understand what you've just said, you are inviting us to go one step further.
Absolutely. But of course, subject to what Muller says. I mean, if Muller says that, well, no, this will cause unfairness to the Secretary of State because the Secretary of State hasn't filed any evidence, etc., then the court may take that into account. But it seems to me, with respect, that this isn't sort of that sort of case. This is a case where, well, subject to what Muller says, if the court is of the view that this is a clear case, then the court can do that.
All
but
right.
for my purposes, I'm entirely content for there to be a substantive hearing in the Upper Tribunal.
Understood. Thank you.
So that is Kalidasan. The next case is Kaliyamoorthy. The application for leave to remain made by that appellant is at page 309 of the bundle. Page 309 of the core bundle, the same application form as a skilled worker. If you look at page 315, you'll see that Mr. Kalidasan has a sponsor. The sponsor has a sponsor license, Prince Foods Limited. They have issued a certificate of sponsorship to employ the appellant as a business sales executive, a job that falls within the relevant occupations, shortage occupations. The salary is 32,000. And again, page 316, under the heading UK immigration status, the appellant asks the Secretary of State to consider the cover letter. If you wish to see the actual certificate of sponsorship, pages 319 to 320. The cover letter, my lords, my ladies, is page 301 of the bundle. You'll see that well, this appellant too made an application for FLR HRO, but he also did what the Secretary of State requires him to do. namely made a skilled worker application. He refers to the witness statement. I'll take you to that witness statement. And submissions, the facts are sort of summarized why he wasn't able to complete his studies. The submissions are then made that all sort of substantive requirements of the rules are met, and you'll see a heading, discussion outside the rules. And paragraphs 37, 38, his life was destroyed by fraud, manipulation by an agency in India. He has A-rated sponsor. It's a skilled role. He has particular skill set, and invites the Secretary of State to grant leave under the immigration rules, all substantive requirements being met, or alternatively grant leave outside the rules. The witness statement by this appellant is at page 102 of the supplementary bundle. So you'll see that he was asked to pay 1 million rupees as university fees, which he paid, and he was told that that further fee would be paid in the sum of £20,000. But once he entered the country, paragraph 6, he was picked by the two agents, and he was told that they would arrange a job, etc. And then for the reasons given, he says he wasn't able to study. Paragraph 10, he tried to enroll at the university. They said that they could not enroll. He could not enroll unless he pays the fee. He felt completely lost. He contacted his mother in India. He went to the police station. And the police said that it's a civil matter. They couldn't do anything about it. Paragraph 11. And then he sets out the circumstances as to how he got his job, how he found the sponsor. Paragraph 26. 25, he apologizes for what has happened. 26 says that, well, grant me leave, use your residual discretion in my situation. The minded to refuse letter is at page 87 of the same bundle. It's the same letter that...
I beg your pardon, could you give me the page again?
Page 87.
Thank you.
So same letter, same language, that the Secretary of State is considering refusing the application because the requirements of the rules are not met, because the appellant hasn't completed the course of study. The purpose of the letter was to give him the opportunity to make a fresh application under a more suitable route. Again, the point is that this is the most suitable route for him. He replies to this letter, and the reply is at page 84 of the bundle. And he says that, well, you haven't really engaged with discretion. He says, well, look at my witness statement, look at my cover letter. you have a discretion under paragraph SW 1.6. But even if that isn't the case, you are still obliged, the letter says, to consider exercising discretion. Again, see the cover letter. So that is the response. The rejection decision is the next document. The decision that is being challenged, page 256 of the bundle. The Secretary of State says the same thing as she said in relation to the other appellant, page 256. Your application has been rejected as invalid and will not be considered for the reasons set out below. So it's not a decision on grant of leave outside the rules or refusal. The Secretary of State isn't willing to consider the application. Page 257, the Secretary of State says, I have considered the above reasons in full and the particular circumstances of your case, and it has been concluded that discretion will not be granted due to lack of evidence to substantiate your claims. Two points. The first being that this isn't, in my submission, a refusal to grant leave outside the immigration rules. The Secretary of State is saying that I'm not even willing to look at your application. Secondly, the point that the Secretary of State makes is flawed. There was evidence. His witness statement is evidence, which the Secretary of State has not referred to or dealt with at all. But even if one assumes that the witness statement is not evidence, there is no obligation in law for an applicant to corroborate his or her account by evidence. The decision maker is entitled to accept an account that is not corroborated if evidence is readily available but hasn't been provided. That is indeed a relevant consideration. But what the decision maker cannot do, in my submission, is to say that, well, I'm rejecting your application because of lack of evidence.
I mean, again, looking at this benevolently, could it be read as saying the evidence you have presented is insufficient to persuade me to exercise discretion?
So,
not that there's no evidence, but that the evidence isn't good enough.
Yeah.
Without reasons as to why that is.
No, but the Secretary of State, with respect, isn't saying that your evidence is not good enough. She's saying that, well, you haven't provided evidence. There is lack of evidence. Lack of evidence. There is lack of evidence, the Secretary of State says. Just immediately above, this is really the conclusion. Discretion will not be granted due to lack of evidence. But even if one keeps that, one puts that to one side, Mr. Kaliyamoorthy does not know whether the Secretary of State accepts his account or rejects it. If she rejects the account, why that is so? I mean, was there anything inherently improbable in the account? Whether it is inconsistent internally or externally. And if the Secretary of State accepts that account, why that isn't exceptional? The Secretary of State hasn't really even applied her mind to the question of the policy, the question whether there are any exceptional circumstances. She isn't even saying that there is nothing exceptional in the case, for the reasons because she hasn't even looked at the application. Again, rejecting this application, again, I'd make the point, defeats the purpose of the policy, defeats the scheme of Section 3. The Upper Tribunal's decision that is the subject of this appeal is page 188. This is a relatively detailed decision, reflective of the fact that a number of different arguments were made. But you'll see that this is page 191. The judge thought that Islam was an answer to this claim. Paragraphs 17, 18, and 19. The judge said that the plain meaning of the word substantiated is not that witness statement is not evidence, but that statement has not been corroborated. The applicant has the burden of proof. It wasn't arguably rational to conclude that a bare witness statement was insufficient. That isn't, in my respectful submission, a good point. I mean, in this jurisdiction, witness statements are often the only evidence.
Well, that's true in many jurisdictions,
in many
not just this one.
Yes. So what is wrong with the witness statement? Is it internally inconsistent? Is it externally inconsistent? Is it inherently improbable? Or is it not sort of corroborated by evidence that is readily available? But again, I make the point that the Secretary of State hasn't even said that this isn't an exceptional case, hasn't even looked at whether to grant leave. And Islam is not an answer, as the judge thought at paragraph 20. Again, what the judge has said is neither here nor there with respect. It is for the court to decide whether the initial decision is unlawful or is arguably unlawful. So next case, Periyasamy. The skilled worker application is at page 460 of the bundle. Again, you'll see that it's the same application form, namely the skilled worker application form. If you look at page 466, Mr. Periyasamy has a sponsorship from Mahis Trading Limited to work as a retail manager. The employer has a license given by the Home Office, has assigned a certificate of sponsorship. This is the application that is made. The cover letter that accompanied the application is at page 301. My apologies, it's not 301. It is 452.
Does the application form refer to the cover letter?
No.
Because the first two application forms,
Yes.
you showed it did specifically refer to the cover letter.
There was an express reference to the cover letter indeed. But no, there was no express reference to the cover letter. Paragraph 2 of the cover letter. Yes. So the application did not expressly refer to the cover letter, but if you look at the cover letter at page 452, you will see, of course, that this expressly refers to the application that is made.
All right, so this answers the question that I raised at the outset of the hearing. So at any rate in the cover letter, albeit there's the slight point about the absence of cross-reference, the cover letter does ask for LOTR.
Yes. So the cover letter explains the circumstances, refers to the witness statement, and then sort of makes a further point that the applicant had problems with police in India because of a link to a particular party, and refers to an asylum claim that had been made, which, as the court knows, wasn't pursued ultimately. But there is, as Mallory pointed out, an express request to consider grant of leave outside the immigration rules.
Is it the same agent in all these cases?
No. These are different.
One of the applications named an agent. This one doesn't in this document. I know.
These are different agents. Yeah. There is of course as the court I'm sure would have noticed there is a problem here, which isn't of course for this court to address, which is
no, it's
for
just
the
a matter of
second
interest.
Yes,
But
different agents, not the same
Not
agent.
a matter that we have to decide, but I'm just interested to see whether it's a common theme.
Yes. So this is the cover letter. There was a witness statement. It is in the supplementary bundle, page 135. He came here to study at Coventry University. When he went for enrollment, he was told by the university that he hadn't paid the fee. He had paid the fee, in fact, to the agent, expecting the fee to be transferred to the university. He contacted the agent. The agent was unreachable. The university was chasing for the payment. His father tried to reach the agent, wasn't able to track him. He went to the university daily, he says, to explain the situation, requesting further time to pay the fee. The university refused to allow him to study. And then he says that, well, his friends told him that they too have been cheated by that same agent. And the only solution was to track the agent to recover the fee. He was told by someone that way forward was to make an asylum claim. He made an asylum claim. He explains at paragraph 7 why that was so. But in the meantime, he found a sponsor. He got the job and asked the Home Secretary to exercise their discretion. That refers to the policy, and requests them to grant the application. The Secretary of State's response was minded to reject letter, which is the same letter that you have seen in other cases, page 118. Same template letter. The Secretary of State is considering rejecting the application because the validity requirements are not met. The Secretary of State is giving the opportunity to the appellant to make a fresh application on the more suitable route. Said this indeed is more suitable route. Pages 118 and 119. Mr. Periyasamy replies to that letter And the reply is at page 116 and 117. He asks the Secretary of State to exercise discretion, refers to the asylum screening interview, the witness statement. He says that he would be at risk in India, not suggesting for a minute that the Secretary of State is obliged to grant leave on that basis. The Secretary of State is perfectly entitled to reject it on the basis that the asylum claim should be pursued. He then says that, well, I've got a job, look at my witness statement that I've submitted, look at my earlier letter, and there are sufficiently compelling, compassionate reasons. The Secretary of State rejects the application. The decision subject of these proceedings is at page 427 of the core bundle. The Secretary of State says the same thing at the outset, that the application is rejected as invalid and will not be considered because the requirements of the rules are not met. I make the point again with respect that what follows is not consideration of whether he should be granted leave outside the immigration rules. The Secretary of State is refusing to consider that application.
There's a slight difference in the language of the first sentence. In the first sentence of the first two decisions, the Secretary of State said you've attempted to make an application for permission to stay, whereas in this letter the Secretary of State says you've made an application. Does anything turn on that difference?
Perhaps it's just, in fairness, nothing more than a slip, I would imagine, because although the Secretary of State on one hand says that there's an application, but then rejects that application as invalid, so what attempted is missing. The letter explains why the rules are not met. There's no challenge as to that. Page 429, after thorough consideration, the decision has been made in accordance with the immigration rules, which isn't controversial, but then while we have assessed the information and evidence submitted, we conclude that the criteria for applying discretion have not been met. Again, this isn't a refusal to grant leave outside the immigration rules. The Secretary of State hasn't followed the policy, but I do also say that this does not meet the Southwark criteria. The reader wouldn't know whether the Secretary of State accepts the accounts or rejects it. If she rejects it, why? If she accepts it, why it isn't exceptional. Why it isn't something that is an unexpected event or a crisis that wasn't anticipated. Unlike other cases, yes.
Oh, I'm so sorry to interrupt, Mr. Mike. There doesn't seem to be a decision at all about the application for leave outside the rules.
Yes. So the only point, the sentence that I've sort of shown you is the only sentence that concerns discretion.
Yeah.
Is there in this case an express application for leave outside the rules? When I was reading correspondence before, it looked as though the proposition was that there was a discretion under SW 1.6.
That was raised in the cover letter that we
cover
looked
letter.
at.
Yeah.
So the cover letter clearly does.
Yeah.
Right.
Whether the response to the minded to letter does is more debatable, but it does re-enclose the cover letter. So,
and the cover letter expressly
Yeah,
makes
I
the
missed
point about.
I missed that one.
But if you need a reference,
You just
again,
remind me of that passage.
page 452 of this bundle,
Of the
of the core bundle, same bundle,
core one.
and
It's
page
457
457.
and 458.
Okay, thank you very much. Paragraph 25.
And the conclusion is the same as in the previous answers. So 30 is leave to remain under the skilled worker,
Yeah, okay, thank you.
and then
Thank you very much.
alternatively LOTR and 31.
Thank you.
The Upper Tribunal's decision refusing permission to apply for judicial review is at page 365. And the key real reasons are at page 366. And paragraph 8, Roman 5 is the judge's view that the Secretary of State is not obliged to consider the information, but the decision states that it has considered the evidence presented, and the Secretary of State has unarguably engaged with the evidence presented. She hasn't, in my submission, but even if she has, she hasn't made a decision whether this is an exceptional case or this isn't. Paragraph 10, the judge says that the Secretary of State has unarguably considered whether to exercise discretion and decided not to. That, I say, isn't the case. And that decision is wrong. The final case, Mr. Muthusamy. The skilled worker application is at page 644 of the core bundle. The same application form that you have seen. It's a skilled worker application. If you look at page 650, this appellant also has an employer, a sponsor. Sponsor has the sponsor license. The job that is being offered is of retail manager, a job that is short in supply for £26,500. There is no, of course, reference to the cover letter in the application form. Makes no difference in my submission. The certificate of sponsorship, if you wish to see it, is at pages 654 and 655. The cover letter is at page 639. See that sets out why the requirements, the sort of substantive requirements of the rules are met. This appellant is a mechanical engineer, has done a BE, has a sponsor, has funds, meet all the requirements, and then there is a request to grant leave outside the rules, page 642 and 643. No witness statement was submitted at that point. The Secretary of State responds by issuing a minded to refuse letter. And you have that letter in the supplementary bundle at page 158.
isn't it?
I think it is.
Looks okay to me.
Yes, sorry, this is, sorry, I was taking you to the minded to refuse, minded to reject letter. I'll just find it. It is,
Oh yes. Is that page 87? No, sorry, that's a different one. Yeah, case 2.
158 does look like a minded to letter because it invites a response within 14 days.
Yeah.
yes, my lord.
It's indexed as minded to reject notice.
Yeah, and it invites additional information.
Sorry, it's 118. My apology. No, sorry. No,
That's a different case.
118, yeah. It is 158. Yes, it is. My apologies. It is indeed the letter. Slightly different in language from the other letters, because in that letter, just at the end of 159, the Secretary of State says that, well, you have requested leave outside the immigration rules, but the Secretary of State is not prepared to consider your request. Secretary of State isn't saying that, well, I'm not going to grant you leave. The Secretary of State is saying that I'm not even going to look at your request. And then the Secretary of State says that, well, you now have an option to submit a fresh application under a more suitable route. The appellant replies to this letter, and the reply is at page 150. The reply sets out the background of the case, a response to this letter, and then there is a response. Asks the Secretary of State to, exercising discretion, apply their own policy outside the immigration rules. And then if you go to page 153, so no witness statement was submitted with the original application, but a witness statement was provided with this letter. See paragraph 18 and 19. So not only this appellant provided a witness statement, but also provided corroborative evidence, unlike other cases, namely a WhatsApp exchange with the agent. And then paragraph 20 sets out further circumstances why he says his case is exceptional. He came to the country, paid the fee by taking a loan from a loan shark in India. So he took loan from a loan shark. The money wasn't given to the university by the agent. The university told him that, well, I cannot enroll you without fee. And he then explains what happened thereafter, provides WhatsApp messages, and invites the Secretary of State to exercise discretion outside the immigration rules. The witness statement is at page 172.
Well, this is the evidence that's summarised in the paragraphs you've just taken us to.
Indeed.
Yeah.
So this is a person who was required to pay £3,000 for the university fee. He had a scholarship for another £3,000, he says at paragraph 2. And he then sort of explains, so this is the evidence for the claims set out in the letter that I've shown you. And he then, just like other cases, invites the Secretary of State to exercise residual discretion, grant leave. See the last paragraph at page 22.
Yeah, but also the point is made that the guidance on LOTR doesn't allow the Home Office to refuse even to consider a request for LOTR.
Yeah. The Secretary of State nevertheless rejects the application. Page 581 of the core bundle is the rejection decision. Like other letters, the letter starts by saying that your application has been rejected as invalid and will not be considered. What follows is not a consideration of leave outside the immigration rules. Page 583. Well, this is a decision which has comparatively more reasons when compared to other cases. But you'll see how the Secretary of State has approached the exercise. The Secretary of State says that page 583, that I have considered a letter from your representatives, but the fact that you have an employment is not enough to override the validity requirements. And the fact that you have a job would not meet the threshold to be considered exceptional. And then the words that I emphasize on, in order to meet the consideration of leave outside the rules. The Secretary of State isn't saying that, well, your case isn't exceptional so as to warrant grant of leave. Secretary of State is saying that I'm not even going to look at your application. And then there's a reference to the point about loan shark, and then the Secretary of State says at the end of paragraph that you do not meet the threshold to be considered exceptional in order to meet consideration of leave outside the rules. Again, this isn't a refusal of leave to grant leave outside the rules. Had it been a refusal, the Secretary of State would have used the language in the policy, would have explained why this isn't exceptional. There is no reference to the witness statement, WhatsApp evidence in this letter. No engagement with that evidence. The author, there is a reference to a previous witness statement. It's not sort of immediately clear whether that is the witness statement that I've shown you or whether there's some other witness statement. But the fundamental point is that this isn't a refusal of leave outside the rules. The reader wouldn't know whether the Secretary of State accepts the accounts or rejects it. If she rejects it, why? If she accepts it, why this isn't exceptional? Why it isn't an unexpected event or a crisis that could not be anticipated? And the Secretary of State declines to consider the application. The Upper Tribunal's decision, the last document that I will show you is at page 518. And the key reasons are at paragraphs 8 and 10. Secretary of State the judge says that the Secretary of State refers to currently available evidence, and that must include the witness statement, WhatsApp messages. And then 10, that the Secretary of State has exercised a discretion against the applicant. Adequate reasons are given, and the applicant merely disagrees with the outcome. And the high threshold for irrationality is not met. This isn't a disagreement with the Secretary of State's decision not to grant leave outside the rules. The Secretary of State hasn't considered that grant. The rejection of the application in my submission is defective, and the judge's decision that the claim isn't arguable is wrong. So I've taken you to sort of key documents in these appeals. There are, as you may have picked from the skeletons and the chronologies, various other refusals, rejections. They are not material to the appeal. There were instances where, following pre-action correspondence, the Secretary of State had agreed to reconsider the matter. But these are the key papers. Lords, Lady, unless I can assist you further, I think I have made my submissions on law and on facts.
Very good. Thank you. Lord Margaret.
Well, there are one or two matters where I might like to take some instructions, if I may. And given that we are coming close to 1 o'clock, I wonder whether we might rise a little early and I have my submissions after lunch.
Certainly. Do you need more than an hour?
No.
Because we could come back at 1:45 if that would be convenient.
Certainly.
If you need longer, then tell us.
Certainly. 1:45 should be.
Fine. Very good. We'll resume at 1:45.
Cool.